Mr. Lorenzen, are you here for capital home management or improvement? Is that right?
Yes, that's correct.
All right, Mr. Lorenzen, if you could sit a little bit closer to your microphone, you're kind of quiet here in the courtroom. If you
Sure.
could just, okay, yeah, I can hear you a lot better now. If you would just maintain that during the trial, I appreciate it. So if you guys could just pick a seat at one of these tables. I'm going to pull up the materials that you've submitted.
Right.
All right. In this case, procedurally is a little bit confusing because there was an initial default judgment and then that was set aside. And so now we're proceeding to trial. Are both sides ready for trial today?
Your Honor, I do have one concern. When we were trying to mediate, Gaynor was never on this case file, and I wanted to clarify it because we could not mediate that until we got clarification. So I looked online where Gaynor's position is. He was retired. He's retired. So I was not dealing with him in the case of this matter. So I have a screenshot of my phone where he claims that he is the president. So I'm confused of the situation where you can kind of change your position or jump back and forth. But what I'm presenting is that I want to at least deal with somebody that I was dealing with, and that was Teresa, not Gaynor.
Okay, so what you're saying is in response to my question about are you ready for trial? You're saying you might not be ready for trial because you need more.
I am ready, but I just need to know if he can actually be on this.
Okay, I understand. Mr. Lorenzen, what's your position at Capital Home Improvement?
I'm president.
And what about this allegation that you're listed as retired on the internet? Is that right?
That is not correct. No.
I have a screenshot, Your Honor.
No, I understand.
I'm sorry,
So,
sorry.
Mr. Lorenzen, why would the internet show that you're retired?
I have no idea. I really don't. I get a paycheck every Friday.
Okay. All right, thank you. So Mr. Lorenzen, what's the position of the person that the plaintiff was previously dealing with? Was it Teresa?
Yeah, she's secretary as far as on the paperwork.
She's not.
Okay, thank you, Mr. Lorenzen.
I could pull it up right now. She's not the secretary.
No, I understand. So based on his representations, would you like more time to investigate? Or are you ready to go to trial now with the representations that Mr. Lorenzen's made?
Can Teresa be present? Can Teresa be present? Because she is there. She's there. We've only talked to Teresa. We've never talked to him.
So would you like to call Teresa as a witness? Is that what you're saying?
Yes.
Is Teresa available to testify, Mr. Lorenzen?
Teresa's not going to be dealing with this anymore. It's a health issue. She's had a recent stroke, and this is not helping at all.
Okay, so what I'm hearing is you'd like to call Teresa as a witness, but she's not available. You didn't know that Mr. Lorenzen was going to be here today, and you're not sure what his position is.
No.
So I'm hearing that you're not actually ready for trial. I mean, I know you know the facts and everything else, but if this detail is going to hold things up,
Okay.
then do you want more time to investigate that and figure out if you can call Teresa as a witness somehow on your own?
Will she ever be present?
I
Because
don't.
that's who
I have no control over that.
We'll move forward.
You'll move forward today?
Yes.
Okay. All right. Thanks. All right. Does either party have any objection to my hearing this case, given that I'm a judge pro tem and not one of the elected judges on the district court?
No. No.
No.
we don't have
I won't hold it against you.
No.
No
I'm
objections.
sorry.
Okay.
Your Honor.
No,
Mr. Lorenz,
That's all good.
objection. Okay, thank you. So we're very limited on time. I've got one more case at least that I want to get to today, and I've got about 45 minutes to do it. So I'm not sure it'll happen, but we're going to try. I've read the introductory materials. Does either side have a witness that they're going to be calling?
My mother.
Okay, and Mr. Lorenzen, do you have any witnesses? Oh, no? Okay. So if you could all just raise your right hand. Do you swear the testimony that you're going to give today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes.
All right, everyone said in the affirmative, so we're going to proceed with the trial. and let me just get people's names right. Mr. Tyler, I apologize. You can proceed when you're ready.
Thank you, Your Honor. It is beyond my comprehension to understand how the installation of 3 standard-sized windows for my kind and loving mother's home could take so long and go terribly wrong. We are here today because the employees of Capital Home Improvement have been dishonest, inconsiderate of my work schedule and my mother's work schedule, and the medical emergencies my mother's was dealing with in the past. They constantly changed the installation dates from September to October, then to the end of December and possibly January of 2023. The blatant disrespect from Teresa Lawrence, constantly yelling at my mother while my mother calmly tried to convey to Teresa why we could no longer accommodate Capital Home Improvement constant changes to the installation dates for the 3 standard-sized windows. Nor could we tolerate Teresa's yelling at my mother, which was totally unprofessional and disrespectful. The dishonesty started with Nolan Archer on August 26 of 2022. Nolan conveyed to my mother and I that there was a good possibility that they had 3 standard-sized windows for my mother's available at Capital Home Improvement's warehouse. That was a lie. Rachel Ward called my mother several times in September with 2 projected dates in September for the installation of 3 standard-sized windows for September. That date was changed. October 5th of 2022, Rachel notified my mother and I that the installation for 3 standard-sized windows would occur approximately 15 days later. That did not occur. However, on or about October 18th of 2022, my mother called Capital Home Improvement and Rachel to convey to her that 3 standard-sized window installation date had changed to the end of December or possibly January of 2023. With my permission, my mother requested a full refund. Teresa came on the phone, started to yell at my mother because my mother requested a full refund. Teresa stated that I had signed a contract. That was false. She was extremely rude and disrespectful to my mother. From the time she started to talk to my mother, she constantly yelled at my mother on the phone. Therefore, my mother had to put her on speakerphone. Since this incident, my mother has displayed increased fear and anxiety. This has resulted in my mother's increasing her home security. My mother continued to exhibit fear and anxiety of retribution from Teresa. Teresa's blatant disrespect to my mother has left my mother fearful of Teresa's retaliation since Capital Home Improvement has been to and inside my mother's residence. This has resulted in my mother's increased visit with mental health provider and her appointments with her PTSD therapist. Family and friends are concerned for my mother's safety and fearful of any retribution from Teresa. My cousin refused to stay in my mother's home because they heard her yelling on the phone. Teresa Lawrence's behavior is rude, aggressive, disrespectful. They do not want to subject themselves to such rude behavior.
So just to be clear, I'm sorry to interrupt you. There was an initial agreement for the installation of the windows. Was there a signed contract? Is that written?
No.
Okay.
No.
And you initially paid a down payment towards that?
Yes.
And is that the amount that you're seeking to recover?
Yes, Your Honor.
And I have here invoices for that amount. My understanding is that you sought then to cancel the order, basically?
Well, no, Your Honor, because due to the fact that they kept changing the dates and I couldn't keep changing my work schedule.
Right.
So I figured, you know what, this is not working.
Right.
And I can't afford to keep changing the dates if you're not going to be able to give me the proper dates.
And so, but ultimately, therefore, because of those difficulties that you've described, you ended up telling them, let's go ahead and cancel this. And that's when they yelled on the phone.
Yeah.
And so the resolution from them was, no, you owe us the money and we're keeping it?
Yes.
Yes.
Okay. And there's no written contract that
No.
you have?
The only copy that I submitted was the actual original contract, but I never signed it.
Okay, I understand your guys' arguments. Did you want to call your mother as a witness? I'm not sure I need to hear it, but if you want to, it's up to you.
Yes, it was just basically to reinforce the fact that when we tried to talk to Teresa, she was very disrespectful. She yelled at me and said she had been in business for 39 years and I didn't know who she was messing with. I didn't know who I was messing with, that I would live to regret it. She was very, very aggressive and confrontational. And I just told her, I didn't understand why she was being so hostile and that my son just wanted a refund. And this was in October. And she said she had to think about it and she never got back to us. And so it's frightening that we, we just requested a refund because the dates kept changing and I was dealing with a medical emergency. And we just could not get her to comply.
Thank you. I understand. Mr. Tyler, other than the amount of the refund, are you seeking any other amounts as part of this judgment?
Yes, Your Honor. I am seeking full down legal fees, gas, and time off from work of $1,930. I'm sorry, $1,930.15.
Okay, I understand. So what's the amount of the refund itself?
For the window installation down payment, that'll be $1,366.15.
Okay, and that's the amount you asked them to refund you.
Correct.
And how much did you spend on proof of service for this?
I spent $400 for when I went for the legal documentation for them to be served.
$400?
Yes, correct.
And did you attach a receipt for that?
I did not, Your Honor.
Okay, and then you had to pay a filing fee here for $50, is that right?
That is correct.
Okay. All right. Okay. All right. I've heard everything I need to hear from the plaintiffs unless you feel like I'm missing something.
The fact that the last time on January the 12th, when we tried to talk to Teresa, she yelled at me again and called me ridiculous.
That was
3
the
times.
time on January the 12th. We tried to do the first mediation and it just went so horribly wrong for them because Teresa was just out of control, aggressive.
And I'm sorry you had to deal with that.
Gaynor was not present. He was not there yet.
No.
All right. Thank you. Let me go ahead and
Thank
hear
you.
from the defendants.
Thank you, Your Honor.
Thank you.
Thanks. Mr. Lorenzen, you've heard the allegations and it sounds like your company refused to give a refund of $1,366.15. Is there a contract at issue here? I didn't see one in the documents.
Is there, I'm sorry, is there what?
Was there a contract, a written contract?
Yeah.
Yes, there was. Was it submitted to this court?
Yes. Yeah, well, that, my declaration, yeah.
Let me take a look. Was that in the defense exhibits?
It should be, yes.
All I've got in the defense exhibits is a declaration from you.
There's a declaration of Teresa as well.
Let me check here. The problem is that there's multiple filings, so there's multiple folders to go through.
Yeah, I know it.
Let's see. Oh, yes. Okay. I've got a declaration of Teresa here, and I've got a counterclaim. And so are you proceeding still on that counterclaim?
Oh, absolutely. Yeah. Yeah.
Okay. So why don't you go ahead and present your arguments against the claim against you and for your counterclaim?
Well, first of all, there was never no dates changed. We take care of our customers big time, obviously 40 years in business. They wouldn't let us schedule to do the install. That's the biggest thing right there. And we offered to give, you can have the windows. I don't care. They're your windows. They're for your house. But they were having none of it. And by the way, this is the 3rd phase of the replacement on their house. We've done 2 other phases. And they just would not let us schedule. He wanted the money back. At the time, the mother didn't. Would rather have her windows.
Your Honor, that was 12 years ago when they.
But if you could just
I'm sorry.
let him go,
Okay.
and then I'll give you a chance to rebut at the end. Sorry, and you can continue, Mr. Lorenz, and I'm sorry for the interruption.
That's okay. And also, Teresa's never said a harsh word to anybody. We've been married 45 years, been together 50 years. I know her very well. She would never say anything to a customer derogatory, ever. And
Well,
I'm
you weren't a party. So, Mr. Lorenzen, you weren't a party to the phone calls, right?
absolutely was.
You were on the phone call?
No, but I was, our offices are
Mhm.
together and I'm sitting at my desk. I hear all the phone conversations of everybody.
Okay, I understand. You can continue. Thank you.
It just never happened at all. And I would have loved to just put their windows in like we always do, and they just weren't having it.
So, but you agree that you had a customer asking for a refund and to cancel the window installation, right?
Well, yeah, way after the fact.
Were these custom windows that somehow you're left stuck with and you can't install
Windows-
somewhere else?
Windows are made to order only these days. Not to say you couldn't go to the box store and buy a window, you can, but it's not going to fit your house. So every window that we do, and we do thousands, is per order for the size we need to do the job properly.
All right, I understand. Did you have anything further to add other than the documents that you've submitted and your testimony here?
I really don't. It's cut and dried. I'd love to put their windows in, but they wouldn't let me. They can have them if they want, but they didn't want them. I'd put them, bring them to them. I don't even care. It doesn't matter to me. But this whole thing's gotten out of hand.
Okay, I understand. Mr. Tyler, I'll give you a minute or two. For
Okay,
rebuttal.
so to clarify that, they're not custom-made windows. So I've already had another company install them. And if you look at if you look at the receipts, it does state that it says standard size windows. And the people that installed it were great, respectful. Installation was just perfect. So I love the service. Another thing is that there is no.
Would you go to for that?
Huh? I submitted that.
Oh, okay.
Yeah. I have the receipt also, but I did submit that there too. So, and it took them about 3 weeks. Now, the other thing I'm trying to address, Gaynor, because I know I'm on a short time here. There's no signed contract physically for me. I had submitted that from the beginning. And this is why we are having a problem, because these are a lot of lies passed around. And all I'm asking is a simple, can you just refund my money? And I do not need your windows no more, because guess what? I've already have windows installed. So there is no need for you guys to come here. And respectfully, if anybody in the right mind get treated the way we did, would you want anybody on your property? I doubt it. So no, I don't want nothing from them, Your Honor. I would just like to have my money back.
Okay, I understand. So in this case, I'm going to find that there was no written contract that was signed by the plaintiff. I'm going to find that the plaintiff asked for a refund of windows after several attempts to try to get installation that were unsuccessful. And I'm going to find the refund was unfairly denied. And therefore, I'm going to find that the defendant owes the plaintiff $1,366.15, as well as $50 for the filing fee here. And I'm going to limit the amount for the service of process to the normal, which is about $50. Just because I don't have documentation to support anything further. I don't have the ability to reimburse for time off or anything like that, unfortunately. And I understand that that was a great deal of time and trouble that you've been through on this, but the total judgment will be $1,466.15. That'll be written up right now. It'll be available electronically to the parties. And then, of course, Capital Home Improvement does have a right to appeal if they want to. And if you want to, you have to do so within 30 days, and you can find documentation on the district court website on how to get that information, or call up the court clerk. And that's all for the parties today. If you'd like a copy of it, just check the electronic docket. It'll be up very quickly. So,
okay.
All right.
Thank you, Your Honor.
Thank you very much.
Your Honor. Thank you so much.
Thank you. I'm sorry that you had such a bad experience with customer service. And just to be clear, that didn't weigh on the party's decision. It's just unfortunate.
She was nowhere around when we talked, and she was yelling at me. Honestly.
Is there a way we can get a printout now, or can we do it?
Can we print one out now or no? Yeah, we can print one out now if you want to
Oh,
wait.
thank you, sir. Yeah, that would be so helpful.
I served my country for 30 years, Your Honor. I wouldn't lie on her. She really did yell at me.
I understand. We're all settled here now. I'll just get the document for you.
What you just witnessed wasn't a dramatic courtroom explosion or a judge slamming a gavel in anger. It was something far more precise and far more damaging to the defendant's case. Slow, careful, legally grounded accountability. This hearing shows exactly how small claims court strips a dispute down to its bones and forces both sides to live or die by facts, not bluster. At first glance, this case might look simple. 3 standard windows, a down payment, a delayed installation. But as the testimony unfolds, it becomes clear that the real issue is trust, consistency, and whether a business can lawfully keep money when it never delivers what it promised. From the moment the plaintiff begins speaking, the tone is noticeably restrained. He doesn't insult the company. He doesn't exaggerate. Instead, he frames the case with disbelief, not outrage, explaining that it is beyond comprehension how something as basic as installing 3 standard-size windows could stretch from September to October, then to December, and eventually to maybe January. That framing matters because it signals to the court that this isn't a customer trying to escape a contract, it's a customer reacting to a process that completely broke down. The plaintiff emphasizes work schedules, medical emergencies involving his mother, and repeated rescheduling, all of which paint a picture of flexibility that eventually reached its limit. Before the court even reaches the substance of the dispute, procedural confusion, already sometimes undermines the defense. The judge explains that the case previously went into default, was set aside, and is now proceeding to trial. That history alone suggests that this matter hasn't been handled cleanly. When the plaintiff raises concerns about mediation, specifically that the person he had always dealt with, Teresa, suddenly wasn't part of the case, the judge treats it seriously. This isn't nitpicking. Knowing who represents a company and who has authority is fundamental, especially when a refund dispute is involved. When Mr. Lorenzen identifies himself as president of Capital Home Improvement, the plaintiff points out that online records list him as retired. The judge doesn't accuse anyone of lying. She simply asks why there's a discrepancy. Mr. Lorenzen's response, that he gets paid every Friday, may sound casual, but legally it doesn't resolve anything. It neither explains the inconsistency nor clarifies why the plaintiff never dealt with him until now. Credibility in court doesn't come from confidence, it comes from coherence. The Teresa issue becomes even more significant as the hearing continues. Both the plaintiff and his mother testify that all communication went through her, scheduling discussions, refund requests, everything. When the judge asks whether Teresa can testify, Mr. Lorenzen explains that she recently suffered a stroke and will no longer be involved. The court shows sensitivity, but the legal problem remains. The company's primary representative during the dispute is unavailable, and the defense is asking the judge to accept second-hand assurances about her behavior. The judge offers the plaintiff more time to investigate or potentially call Teresa later, which is a critical moment. Any claim that the plaintiff was rushed ends right there. He chooses to proceed, signaling confidence that the evidence already speaks for itself. As testimony moves into the core facts, the absence of a signed contract becomes central. The plaintiff confirms that there was no signed agreement, only a down payment. That distinction carries enormous legal weight. Without a signed contract, the company's ability to enforce penalties or retain funds becomes much weaker, especially when performance never occurred. The plaintiff explains that the installation dates kept changing, that he could not continue adjusting his work schedule, and that ultimately he requested a refund because the situation had become unworkable. The judge summarizes this clearly, ensuring the record reflects that the cancellation followed repeated delays, not sudden buyer's remorse. The emotional core of the plaintiff's case comes not from anger, but from concern for his mother. Both testify about phone calls where Teresa allegedly yelled, acted aggressively, and made statements that left his mother fearful. The mother describes increased anxiety, heightened security at her home, and fear of retaliation because company representatives had already been inside her residence. Whether or not every emotional detail influences the legal outcome, it humanizes the dispute and reinforces why the plaintiff no longer wanted the company on the property. When the defense finally responds, the narrative shifts, but not in a way that helps them. Mr. Lawrenson insists that dates were never changed and that the company tried to schedule installation, claiming the plaintiff wouldn't allow it. He emphasizes that they've been in business for decades and that Teresa would never say a harsh word to anyone. However, under questioning, he admits he wasn't on the phone calls and only overheard conversations. That admission weakens the denial significantly. Courts prioritize direct knowledge over assumptions, especially when credibility is contested. The defense's strongest argument is that the windows were custom-made and therefore non-refundable, but that argument collapses under scrutiny. The plaintiff explains that another company installed standard-size windows in roughly 3 weeks and submits receipts showing they were not custom products. This single fact is devastating. If the windows were standard and replaceable, then the justification for holding the deposit evaporates. The judge recognizes this immediately, focusing on whether the company truly suffered a loss that would justify denying a refund. The judge's demeanor throughout is critical. She does not reward theatrics and she does not punish attitude. She focuses narrowly on contract formation, attempted performance, and fairness. She allows both sides to speak, limits interruptions, and repeatedly clarifies the facts for the record. This careful approach strengthens the eventual ruling because it leaves little room for appeal based on procedural bias. When damages are discussed, the plaintiff asks for more than just the refund: service costs, filing fees, time off work, gas, and legal expenses. The judge grants only what the law supports. She allows the refund and filing fee, limits service costs due to lack of documentation, and denies compensation for time and inconvenience. This restraint is important. It shows the judgment is not driven by sympathy, but by statute and evidence. The final ruling is concise and precise. The judge finds that there was no signed contract, that the plaintiff made reasonable attempts to complete the transaction, that installation failed due to repeated delays, and that the refund was unfairly denied. She orders Capital Home Improvement to pay $1,466.15 and explains the appeal process clearly. There is no humiliation, no lecture, just resolution. This case illustrates a crucial lesson for both consumers and businesses. For consumers, it shows that preparation, documentation, and calm persistence can prevail without theatrics. For businesses, it's a warning that longevity and reputation do not excuse poor communication, shifting stories, or holding funds without a solid contractual basis. When excuses collide with receipts, excuses lose. In the end, justice here wasn't loud or dramatic. It didn't rely on shouting or shaming. It relied on consistency, credibility, and the simple question at the heart of the dispute: if you never delivered the windows and there was no signed contract, what legal right did you have to keep the money? The court answered that question clearly, and that answer is why the plaintiff walked out with a judgment in his favor.